We'll now call the next case on the docket, 125604, State of Kansas versus Terry Eugene Ross Jr.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. And I would request 2 minutes for rebuttal.
2 minutes is granted. Thank you.
Thank you. The first issue that I would like to address today is the issue regarding the consolidation of defendants' cases for trial. Case law tells us that joinder remains the rule and severance the exception. When analyzing an issue of joinder, an appellate court determines which of the 3 conditions precedent the district court relied on. And there are 3 options: same or similar character, same act or transaction, 2 or more acts or transactions connected together or constituting parts of a common scheme or plan. Once that is determined, then the court looks at whether there is substantial competent evidence to support the district court's findings of fact, using a deferential standard towards those findings of fact. Then the court determines whether the district court properly concluded that a condition precedent had been met using a de novo standard. And finally, the court considers whether the district court abused its discretion in allowing joinder of the cases. The central theme here in these 5 cases was defendant's dominance and control over his wife and stepdaughters in the home. The district court relied on the 2 condition precedents of the crimes being the same or similar character and constituting parts of a common scheme or plan. The court found that the cases were of same or similar character. And we know from Barksdale, crimes are of the same or similar character when they're factually similar in the mode of trial and kind of evidence required, or they carry a similar punishment. Additionally, the statutory condition generally requires multiple commonalities, not merely the same classification of one of the crimes charged. Here, all of the charges involved the same mode of trial, the same kind of evidence, and the same kind of punishment. Additionally, they all involve some form of emotional, physical, or sexual abuse against the victims. They involved AR or her daughters, and all were witnesses in the cases. The offenses occurred in the residence that all of the victims lived in, and they involved a singular motive of defendant to physically and psychologically control his wife and stepdaughters. The charges by their very nature showed dominance and control over these women. So it's our position that there was substantial competent evidence to support the district court's factual findings. And additionally, those factual findings supported the legal conclusion that these crimes in these 5 cases were of same or similar character. Then the district court, also found that these cases had a common scheme or plan. In the jail calls, the defendant referenced the 2 felony cases, the DV case and the sex case against the stepdaughters. Additionally, the 2 felony cases provided context for the 3 misdemeanor cases, which were the jail calls. He had an ongoing plan. The evidence showed he had an ongoing pattern of behavior with the victims to physically and emotionally manipulate and control them. He physically abused AR while her daughters were home. He threatened AR in the presence of her daughters. He physically and sexually abused both daughters, abuse that they disclosed when the domestic violence case was initially, when law enforcement were initially contacted and investigated the domestic violence. And he threatened to beat the girls if they told anyone about the sexual abuse. It's our position that substantial competent evidence supported the court's factual findings, and those factual findings supported the court's legal conclusion that there was a common scheme or plan.
The district court's factual findings were not appealed, correct?
No, they were not.
I want to go to preservation of the objection on the 911 call that, mentioned the word rape and then stopped.
Yes.
Did the state preserve for our consideration the panel's conclusion that the defense attorney satisfied the contemporaneous objection rule of KSA 60404 as to the inadvertent playing of that part of the unredacted 911 call? And I'm asking that because after looking at the record, I never saw the word objection. And there was no ruling on an objection, but there was a request for a remedy, so to speak, to have the redacted phone call sent to the jury. So is it preserved that there was no objection?
Admittedly, we argued in the Court of Appeals that there was no objection. Admittedly, we did not petition the Court of Appeals determination that there was an objection. However, this court has said in Senard that they can look at preservation and whether there is an objection or not, even if the state has not put it before you. So I would point you to that. But you are correct. The word objection, since you've asked me, the word objection is never said. That video or recording, my understanding, as soon as the word rape came out, it was stopped because the state recognized what had happened. It was, I do not recall if there was immediately a bench conference, but I do know the recording was stopped. Then defense counsel, it's later, he's given time to think about it. I mean, when they discuss what happens, and then later on, he tells the district court, when the district court asks, what do you want me to do? Are you asking for a mistrial?
Right. I understand that there was a discussion and there was a remedy requested and given, but there wasn't really a ruling from the court. So how much and you argue about the fact that there was a remedy given. And so I think.
And that remedy given, defense counsel specifically said he did not want anything done.
Right.
He told the court he did not want to highlight it. He didn't want to do anything, and he got what he asked for.
What's your strongest argument that we can consider the fact that you have argued about the remedy requested and given, that it is preserved in totality as to our consideration of the remedy given, but also whether or not there was an objection? What's your strongest argument we can consider both of those things?
I would point to your this court's determination in Senard that it on its own can look at preservation and determine that. Additionally, we did mention that as far as our argument regarding how the Court of Appeals handled the cumulative error analysis. And in our reading of the Court of Appeals decision, they determined that it's a bit confusing, but they determined that that 911 issue was not preserved, it seems, but then they resuscitate that for the cumulative error analysis. And it's our position that if you've determined that it's not preserved, essentially abandoned by the defense attorney when they very clearly said, I don't want you to do anything, that cannot be brought back up and used in a cumulative error analysis.
The state did not appeal the panel's decision that, about the mutually exclusive verdicts, correct?
No, we did not.
So in the cumulative error context, the panel discussed an error from the jury's mutually exclusive verdicts. But we can't aggregate that with other errors for cumulative purposes. Can we, or can we?
Can you say your question again?
Well, can we consider, if we find that there are errors, and then we look to whether cumulative error prevented the defendant from having a fair trial, can we consider the mutually exclusive errors that have now are now accepted as part of the cumulative error analysis? Because they're going back, remanded.
We, in petition, I understand, in petition, we argued that essentially those errors regarding those two counts being mutually exclusive should not, defendant should not be given the benefit of including that in the cumulative error analysis, because he never objected when the verdict came in, nor at sentencing. There was never an issue with those two counts, or to the fact that had an objection been raised at the time the verdict came in, it's quite possible the court could have sent it back on those two counts and said, listen, it's one or the other. You can't find the defendant guilty of both. It's one incident. And so you have to decide, either she was, and I don't recall the age, she was either under 14 or older, because it had to do with, it was one act, but it had to do with when the jury determined that it occurred. So had defense counsel objected at that time and had a problem, it could have possibly been cured. And so it doesn't become an issue until on appeal. And so it's our position that because of that, while we are not saying it was not error, we don't believe that it should now be funneled into the cumulative error analysis.
Is it possible to send simply those two alternative convictions back and affirm the rest?
I believe it is possible.
On the joinder question, the Court of Appeals analysis relies, as far as I read it, pretty much exclusively on their own precedent in the Coburn case. And the Coburn case was a 2008 Court of Appeals decision that said that aggravated indecent liberties and possession of child pornography are not similar enough to be joined together. So my question to you is, are you arguing that Coburn was wrong, or that this Court of Appeals panel incorrectly applied their own precedent?
I have to say, I did not think about it that way. But
Well, let me put it this way. If Coburn is correct, that ag indecent liberties and possession of child pornography are not similar enough to be joined, that would suggest that very few cases can ever be joined.
and I would agree
Is
with
that correct?
No, that is not.
And why
correct.
not?
And going back to that, I believe that aggravated indecent liberties and possession of child porn are substantially similar.
So how would you, what test are you asking us to apply to the statutory interpretation question of how we determine legally which kinds of charges are similar enough?
I believe it is, it is fact-based On the cases, it's going to be, as we know, a case-by-case situation based on the facts that occur within the cases that the state is asking a court to join, and is here looking to the facts. It is clear that there was a central theme in these cases, and the crimes charged by their very nature speak to that theme of dominance and control. So I think it's going to depend on the facts.
So when the statute 3202 sub 1 says same or similar character, I guess I understand your argument to just be, we should give that an expansive reading.
Possibly, and same or similar character additionally is, it has been looked at as even so general as same mode of trial, same type of evidence, same kind of punishment. And so I think that even is kind of easier than what I'm even asking for here.
What I'm looking for is, so if this case comes out in your favor,
Mhm.
the court will have to articulate presumably some kind of a test, or at least at a minimum, an articulation of what this means in the statute, if the crimes charged are of the same or similar character. So I'm just asking if you have a preferred way to answer that question in a precedential way that will apply to future cases. Like, how do we know when the crimes charged are the same, have same or similar character?
I hate to say it's.
Is
one
it
of
we
these
know it when
things
we
you
see it,
know when
or?
you see it, and here, that's kind of how I feel about this case. And because my focus is on this case, that's how I would argue it, but yeah, unfortunately, it is kind of when we see it, but that doesn't necessarily help you.
Doesn't that mean you have to put meat on the bones of same or similar character with the facts found by the district court if they're supported by substantial evidence?
Yeah, yes, that would help. I mean, and that's where the court's factual finding becomes important. And where an appellate court cannot reweigh or put themselves in the shoes of the district court. Seeing I am out of time, I will come back.
All right, thank you.
May it please the court, again, Terry Ross appears through counsel, Jacob Nowak at the Appellate Defender Office. I also, Justice Wilson, want to start with the scope of the state's petition, because I think there might be an issue with a lack of petition on a necessary issue for this court's review, because the panel in this case, when it held that there was error on the consolidation, it held that that was individually reversible, and it did so on alternative grounds. It set its decision out in different sections. Sections 1 and 2 of which it respectively found that the cases were not of similar character and they were not of common scheme or plan. That's at the Westlaw sites of 6 to 16. But then in section 4, what it titled fatally prejudice at Westlaw 8 to 19, it did the second set of the analysis and found this joinder was reversible regardless of whether or not one of those statutory conditions precedent was met. That section opens. Even assuming, for the sake of argument, that one of the joinder requirements under KSA 22-3202-1 was met, the district court was still under a continuing duty to grant a motion for severance to prevent prejudice and manifest injustice to the defendant. They then conduct that analysis and close with, because the joinder was prejudicial to Ross in the sense of denying a fair trial, justice requires severance of the sexual abuse charges from the domestic violence charges and the protective order charges. As a result, we reverse Ross's convictions and remand this case for separate trials. There's no fair reading of the state's petition that petitioned that second adverse holding, that these were reversible regardless of whether or not the statutory conditions precedent were met. So that issue.
So Help me understand that.
Sure.
If the state petitions for review and says the Court of Appeals got the joinder issue wrong, that's not sufficient.
Correct.
Why not?
I'm going to cite the state fee sheets for you because we dealt with all of this in state fee sheets. But there was a petition before this court on KSA 6455 issues and relevance. We also, in that issue below, addressed undue prejudice. Now, the Court of Appeals in that case ruled in favor of the defendant in state fee sheets on those initial issues. And so it never addressed undue prejudice.
Well, the district court did address prejudice, however,
Yes,
and it said that the probative value outweighs the prejudicial effect of this evidence.
yeah, and the Court of Appeals overturned that ruling in its decision here. And so, again, I'm asking the court to apply state v. Sheets where it said, finally, we note the panel declined to address undue prejudice under 6455 as it found the evidence irrelevant. Sheets failed to cross petition on that matter. See Supreme Court Rule 803C3. Consequently, we do not proceed to undue prejudice. Again, here we have joinder, which the statutory conditions precedent, the state has petitioned, but it did not petition undue prejudice. So under your rule 803B6C Roman numeral 1, the Supreme Court will not consider issues not raised before the Court of Appeals or issues not presented or fairly included in the petition for review, cross petition for review, or condition.
So when the petition for review specifically cites as its claim of error, and I'm reading from the petition for review, the panel erred in finding that the district court erred by consolidating defendants' 5 cases for trial. Why doesn't that subsume all of the Court of Appeals reasoning and ruling?
Because, and obviously this court can review that petition and draw its own conclusions, but there is not a single instance in that petition that addresses the undue prejudice analysis by the Court of Appeals. And that I've made that argument, it's now before the court, but that's kind of the point of why joinder of unlike cases is untenable, because what we've got here, what we've always said, and this I think far too often gets boiled down to risk of juror confusion. But what we've said since 1930s is that the reason we don't do this is because there will inevitably be some jumbling of the 2 cases at trial, which would tend to prevent the concentrated consideration of each case, which is indispensable in matters of this gravity. And yeah, that applies to the juries, but it applies to everybody involved in the cases. It applies to prosecutors, defense attorneys, judges, appellate defense attorneys, and prosecutors in the appellate bench. Because every human, not just juries, have a limited amount of mental capacity to dedicate to an issue. And our focus is going to become more dulled the broader that scope of review becomes. And we can see it all throughout this case. I mean, the prosecutor in this case violated the order in limine by playing an unredacted version of an exhibit. I've never seen that error before. I imagine I'll never see it again. Do we think it's a coincidence that that type of error occurred in a case where we consolidated 5 unlike cases with darn near 50 plus counts? Or do we think it's because, hey, they had too much evidence to handle and they weren't able to have the concentrated consideration that's necessary and indispensable in matters of this gravity?
Let me ask a quick question. I'm sorry to change the subject, but still on this preservation issue, appellate courts, apply a 3-step test, right? On decision to consolidate.
Yes.
Right? That's State v. Smith, Parker.
Yeah.
Okay.
Initially Gaither, but yeah.
Okay.
It's been said.
So the prejudice prong is the 3rd part, the 3rd step. So just so I can understand what you're saying that if the state challenges the joinder, or no, I guess if the issue is, I guess on the petition for review, because the Court of Appeals challenges the Court of Appeals finding on joinder, you're saying that the state has to mention all 3 steps of our established test in order to preserve it?
Not necessarily. So reversibility is the last
The third step,
third step in that leg.
right?
And I'm fine with the state wanting to put all their baskets into whether or not the statutory conditions precedent were met, because if that was the only issue, then we don't even need to get to reversibility. So the state's got a choice, they can do that, but where the Court of Appeals ruled in section 4 in favor of Mr. Ross is on the second step. The courts have discretion, they may join cases, and so they need to ensure that if they're not going to, if they're going to do that, it will not cause undue prejudice to the defendant. If the Court of Appeals rules that the statutory conditions are not met and they shouldn't have been joined, consolidated, even if they were, because of the undue prejudice, I think that they need to petition both of those issues. Now, it can be in the same issue heading, but there needs to be an argument in there on both of those adverse holdings.
What prejudice is there to joinder other than the fact that you have child sex? I mean, statutory rape joined with aggravated battery. What other prejudice is there to the defendant to get the statutory rape tried with the aggravated battery other than sex with a child, which was what was argued so vociferously was unduly prejudicial?
Oh, well, you always have the sort of omnipresent concern of the jury might use this as propensity evidence against the other charges, particularly when from the very outset of this trial, the state told the jury to consider this not as a single incident, not about any one single incident, it's about a course of conduct. So you have that concern, but also, again, it's back to it prevents the concentrated consideration that is necessary for these cases. We see it with the state making that blunder of the evidentiary ruling. We can see it with the jury returning logically inconsistent verdicts and mutually exclusive verdicts. Far less likely that that happens in that situation. We can see it where both the trial prosecutor and the district court at the motion for new trial failed to recognize the mutually exclusive error issue, even though the trial prosecutor got up there in front of the jury and said, hey, this is one incident. It overlaps a date range. And unfortunately, that gives us different crimes, whether or not she was under 13 or over 14. You got to go back and pick one of these incidents. But then we are just a few weeks later, the state has confused itself because it cannot concentrate on this broad scope of evidence. And it's presenting to the court that no, we gave them multiple incidents to consider. This is just a merger issue. And the court adopted that argument, even though we can look at the record and see that it's just false. And then we can also see it throughout the appellate process as well. The only
But the
facts-
merger issue was only on the inconsistent verdicts.
Sure, I'm compounding, I'm showing all of the instances where we have little errors based on lack of focus that would not have occurred, or most likely would not have occurred, if this had been 3 separate cases that they could have focused on. For instance, I found this shocking because Sedgwick County handles a lot of trials. They have, and relative to the number of convictions they get, they have very few cases overturned on appeal. These are the only facts the state cited to and on its off-grid case and provided a factual citation for. While talking to HL and DL, officers discovered that Ross had sexually touched both of them. That's the only briefing they did on the facts of the off-grid case. You don't have the appellate success rate that Sedgwick County does with that lackluster briefing on the facts. And
Wait a minute, aren't you leaving out quite a few important facts, like the fact that there were cameras everywhere in the house? The girls had to wipe up their mother's blood. The child testifying that when the defendant tried to have sex with her, it hurt and she told him to stop. How is that not abusive as opposed to simply sex?
so I guess I'm not positive on which facts the court's referring to. There was a 3-page statement of facts by the state. I am positive that's all they gave a factual record pin site for on this sex offense cases, other than, and then he was then convicted of these, which they later included. And that's an obligation of the parties. This court's rule 602, 602 and 603 put an affirmative obligation on the parties to place a record pin site in their argument, directing this court to any statement of facts. That was the main crux of my reply brief to the Court of Appeals, was that, yeah, they have this very sparse statement of facts, which is what I had read that sentence earlier. Then later in the body of their argument, they include a very fact-intensive argument with no record pin sites. And a lot of that argument is not true. I don't think the state intentionally misrepresented it, but it's just not true. Like, for instance, in there, it says that AR was sexually abused. There's no evidence of that at trial. It says that HL was physically abused. There's no evidence of that at trial.
So, sorry to interrupt, but you spent the bulk of your argument,
Sure.
I think, arguing briefing inadequacies on the state's part. In the time you have left, can I talk a little bit about the merits?
Absolutely.
And I want to ask you similar questions to what I asked the state about the Coburn case.
Right.
The Court of Appeals panel in this case relied heavily on Coburn. You would agree with that?
Correct. Yes.
And so just very bluntly, I guess, do you think Coburn was right when it held that possession of child pornography and aggravated indecent liberties are not similar crimes that can be joined?
It's a unique question because the law on sex offenses has changed so dramatically since Coburn came down due to Prine, KSA 6455D, and all of that. Under today's framework, I don't think they were, but back then, I never practiced in that area, or at that time. Perhaps we viewed sex offenses as more distinct. Obviously, now we don't.
Well, am I wrong to conclude, reading the Court of Appeals opinion, that that is the linchpin of their holding?
No, I think they even
quote
recognize as much themselves at one point in their opinion. They say that Coburn would probably no longer be good law to justify separating HL's or allegations from DL's allegations, because there's no meritorious argument for it anymore, because KSA 6455D exists. We all recognize that sex offense cases are like and similar. To your question that you presented to my opposing counsel on what sort of, if you were going to set a precedential rule for how to apply these. So on same or similar specifically, it's a two-pronged test. First, they have to be of the like or general character, and then we get to multiple commonalities. So I've always interpreted that multiple commonalities, that's case by case, fact specific instances. But before we even get there, the crimes have to be same or similar. They have to be, apologies, of the same classification. And I think the legislature, what I would do if it was my role to set this precedential rule, is the legislature's kind of already done that for us. When they wrote the Kansas Criminal Code, they grouped in crimes together based on their similarities in various articles. We have crimes against persons, we have sex offenses, crimes against property, crimes against governmental functions. I would say if they're in the same article of the Kansas Criminal Code, they are similar enough to move forward to that second prong of the test, which is now we have to look towards whether or not there's multiple commonalities between them. If that makes sense. And kind of to bring it back to the general focus, that when I look at these, I apologize, I see my time is up. May I
You may finish.
briefly
yes.
finish? When I look at these three statutory conditions precedent, they're all designed to allow us to keep focus. Same or similar could cover a broad scope of time, but we have one or a couple very light legal concepts for the jury to consider. Same act or transaction might have a bunch of different legal concepts. You could have a burglary, kidnapping, or rape all together, but if it all happens at the same time, the jury is allowed to focus on a subset of facts to apply those broad focuses to. And a common scheme of plan keeps the jury's focus because we see a beginning, middle, and end in that. And so that's sort of how I've always viewed those. And in this case, for the reasons we argued in our briefing and reasons put forth by the Court of Appeals, there may be misplaced reliance on Coburn notwithstanding.
Yeah, that just to summarize your answer, I think you said that even if Coburn's wrong and the Court of Appeals didn't need it, their ruling with respect to the domestic violence and the sex charges is still correct.
Is otherwise sound. Coburn should not be applied to keep sex
Well,
offense
and
cases.
let me just say before you sit down, I have the memorandum decision from the district court, and I did an extraordinary job of going through the steps that we require, the 3 steps, and even in 10 different ways distinguished why Coburn doesn't apply to these particular cases. And I'm troubled by kind of the recategorization that the Court of Appeals did based upon what I think is a pretty thorough ruling from the district court in explaining the rationale for consolidation. And I guess even in spite of Coburn, I think the district court distinguished why Coburn doesn't apply to these facts if it still was good law.
Yeah,
Is
is there any specific portion of it that you would like me to address, or just?
Here's how we do it.
Yeah, so one of the problems with, on that first one, the same or similar offenses, is that we don't get to multiple commonalities because kidnappings and sex offenses aren't similar. On the common scheme of plan, the Court of Appeals did an excellent job of pointing out, we can look at that trial and there's no connector there. There's no evidence of this common scheme or plan. And certainly, into my original point, state didn't provide any record citation for any evidence connecting these for us. And the Court of Appeals needs some avenue to eventually say, if you're not going to provide us with the record cites, we're not going to go do your job for you. And that's what they did.
But they in fact did though, didn't they? Even though they said that, they went to the record and they cited the record, didn't they?
Not sure specifically what you're referring to. They said that they're not going to scour the record for this. The state provides, and that we don't find any citation. And
They said, we don't have to scour the record, but then they went ahead and looked at the record, correct? They didn't say, we're not going to look at it, so we're going to assume it's not there. They went ahead and looked at it, didn't they?
Yeah, I assume they looked at the record. I just assume they didn't go and scour for things that they didn't find on their own. That's the point, is that the state made a lot of allegations in those unsubstantiated block portions of the body of their brief that had no record cite to them, that are not actually true from my reading of the record. They didn't go confirm or deny anything that the state didn't provide a record cite for. But they looked at the record. We always look at the record in some capacity.
Well, but they never went to that final step to say, therefore, we are going to assume it's not in the record. They never said that.
I
did
do
they?
wish they had said the argument was abandoned or something to that sense. They did not go that far in saying. With that, if there are no further questions, I thank the court for its time.
All right, thank you. Ms. Kuhn?
May it please the court, speaking to the inadequacy of my brief. First, regarding the evidence that was considered by the district court on this joinder issue, this was motion practice. This was a motion asking the district court to join these cases. As a part of that motion hearing, the state proffered the probable cause affidavits from the 5 cases. Additionally, as arguing what would support joinder in this case. So I believe my brief speaks to the fact that the state proffered those affidavits, and that was the evidence that the district court looked to determine if these cases met the conditions precedent. This is not a situation, I don't believe that the state was required to prove conditions precedent beyond a reasonable doubt, or put on multitudes of witness testimony to have the district court make this decision. Instead, we have those PC affidavits. We proffered those to the court, and I believe that was sufficient for the district court to look to make their determination.
And we can consider those.
Yes, you may.
Can we also consider the evidence submitted at trial that adds to those?
Yes. Speaking to the attack on essentially my statement of facts in the brief, in this case, there was no argument as to sufficiency of the evidence supporting the specific sex charges that defendant was convicted of. So in response to that, I didn't feel it necessary to set out in explicit detail the testimony that supported all of those sex charges that was presented in the district court.
Can you speak to counsel's allegations or assertion that aggravated battery is just not the same as sex with a child, as applied to the facts in this case? Violence versus sex. Is that all it is?
No. It's our position, again, as what I argued originally, is these crimes involve dominance and control. Sex crimes, as this court knows, they aren't just about sex. They are about dominance and control over a victim. As domestic violence is, this man was exhibiting dominance and control over the women in his home. And that's what each of these cases involved. And this was the common theme throughout all 5 cases, even to the point when he is arrested and he is in jail and he is continuing to contact his wife and questioning, why did you have a safe word? Why these charges from the girls that's going to put me away forever? He's constantly has control.
How is that violent?
Excuse me.
How is that violent?
I believe the violence comes from and the phone calls maybe not necessarily violent, but they do. And I believe he did threaten some things in those. I don't recall all. I know there are at least 20, 23 maybe.
Did you
all-
pin
all the-
sight to any instances of violence in the phone calls?
I don't recall, but my brief would speak to that, whether I did or not. But I did cite to the PC affidavits and what they alleged occurred in those phone calls. As my time is up, I would simply ask that this court reverse the Court of Appeals and affirm the defendant's convictions. Thank you.
Thank you to both counsel for your arguments. The court will take the matter under advisement.